السلام عليكم ورحمة الله وبركاته. الحمد لله رب العالمين، وأصلي وأسلم على سيد الأنبياء والمرسلين نبينا محمد وعلى آله وصحبه أجمعين. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. رب زدنا علما، رب زدنا علما، رب زدنا علما نافعا. آمين. Alhamdulillah, we are discussing about legal interpretation in legal philosophy component. We have in the previous session talked about the early legal engagement of the Sahaba radiyallahu anhum, their ijtihad, which culminated in the dualism of Ahlul Hadith and Ahlul Ra'i. And we explained that this terminology or classification needs further tahrir and tanqih. It is an established classification. These two groups existed. However, understanding their methodology and the shifts which happened between these schools, and we refer to the Maliki, Shafi'i and Hanafi madhahib, this needs further tahrir and tanqih, clarification, in order to avoid the common confusions revolving this classification. This legal interpretive community further developed into a very famous classification in Islamic jurisprudence, which is also a point of confusion because tahrir and tanqih has not been undertaken in this classification also. In the books and works of usul al-fiqh, this is considered to be from the basic discussions and classifications, that the methodology in usul al-fiqh or jurisprudence is of two types: the method of al-mutakallimīn and the method of al-fuqahā. So we have dualism here also. We have the manhaj of mutakallimīn method of mutakallimīn and the method of fuqahā. Fuqahā. Mutakallimīn refers to ilm al-kalam, the science of theology, in which aqidah is engaged and understood based on rational principles. However, this term has a specific meaning when we use in usul al-fiqh, in jurisprudence. It means that these scholars who are referred to as mutakallimīn, and they are the majority, the Shafi'is, the Malikis and the Hanbalis, primarily Shafi'is, because the Shafi'i Imam, the Imam of the Shafi'i madhab, Al-Imam Muhammad ibn Idris al-Shafi'i rahimahullah, is from the main and the early propounders of usul, who compiled a work which has reached us in usul al-fiqh. The works of other scholars have not reached us, or they may not have compiled any specific work in usul al-fiqh. Like take the example of Al-Imam Malik rahimahullah. His book Al-Muwatta is from the early books of hadith, and it contains other fields of knowledge also. It can be considered a book of usul, because Al-Imam Malik, he prioritized opinions, and he exercised his own ra'i in this book, but it belongs to the genre of hadith, and we can extract usulul fiqh from it. We can extract the method of Al-Imam Malik from it, but he did not compile it as a specific book of usul. Same applies on Al-Imam Abu Hanifa, Al-Imam Ahmad ibn Hanbal. So it is primarily a Shafi'i method. The method of Mutakallimīn means that they devised usul first based on rational considerations, and in this they were influenced by theology, which is also which follows the method of rationalizing Aqidah, basing and understanding Aqidah on mujarrad rational principles, and from these usul, the principles which they devised, they extracted the furu, they extracted fiqh, or they based this fiqh and the practical masail in all chapters of fiqh on these usul. This is the meaning of the method of Mutakallimīn when we use it in legal perspective. And it also means that they were influenced by ilmul kalam, theology, and they used these principles in understanding legal matters. So the books of scholars compiled based on this first method of Mutakallimīn, is filled with kalami discussions. It is filled with theological considerations and discussions. The method of Fuqahā means, and it refers to primarily, and we can say only, to the Hanafis. It is the Hanafi method. Fuqahā here means Ahnaf. When used in legal perspective, in jurisprudence, it means it is the opposite of the first method. They extracted usul, principles, based on the practical masail. Because their imam did not compile any work of usul, so what they had was practical masail, fatawa, verdicts, fiqh, which the immediate students of Al-Imam Abu Hanifa compiled, particularly Al-Imam Muhammad ibn al-Hasan al-Shaybani, rahimahullah. We have Abu Yusuf, and they also served as qadis, judges in the Khilafah, Al-Khilafah al-Abbasiyah. So they had practical experience, they had verdicts, these verdicts were compiled. These are the immediate students of Al-Imam Abu Hanifa who compiled his legacy. So what they had was corpus of fiqh, practical masail in all chapters of human life, with the verdicts and the discussions between students, because the method of Al-Imam Abu Hanifa in compiling fiqh was very unique. It resembles modern day conferences. In order to discuss a mas'ala, we engage experts from across the spectrum, and we arrange a conference in which they deliver their experiences and knowledge, and then we agree on the solution to that problem, or we reach a scholarly consensus. This was the method adopted by Al-Imam Abu Hanifa, and it has evidences. I will not go into that. It has evidences from the sources, and when you reflect on his method from the original works of Hanafis, you will see that he would sit with his students and they would discuss the mas'ala together. He would give his opinions, he would listen to the opinions of his near students who were also great scholars, and at the end of the discussion they would reach a scholarly consensus, and the masail would be compiled in this manner. So what Hanafis had was the corpus of masail, fatawa, verdicts, these discussions, and they extracted, or before that, the Hanafi imams, they relied on the method of particular Sahaba, as we have explained, that the four schools are the culmination of the Sahaba, radiyallahu anhum. Different methods. Abdullah, and some of these Sahaba, they became very prominent in ijtihad in certain cities. And we pointed to that. Abdullah ibn Umar radiyallahu anhuma in Al-Madinah, Abdullah ibn Abbas radiyallahu anhuma in Makkah, Abdullah bin Mas'ud radiyallahu anhu in Kufa or Iraq. So Hanafis and Ali radiyallahu an also, they relied on the masail of the Sahaba. And Sahaba also did not compile usul. Yani Sahaba did not write works in which they compiled principles in a very orderly fashion. From the Sahaba we have masail. How did a particular Sahabi act in this mas'ala? What was his ijtihad? What was his verdict? And when we reflect on these verdicts, particularly the Khulafa who were in the position of authority also, so their verdict and their ijtihad became authoritative, like Abu Bakr, Umar, Uthman and Ali, particularly Umar, because Allah subhanahu wa ta'ala granted him a longer period of time. We reflect on these verdicts and masail and from legal perspective and try to understand what were the considerations of this particular Sahabi in giving this verdict. And we extract the asl, we extract the principle based on which we can further base our ijtihad in future in solving unlimited masail. So this is how the Fuqahā or the Hanafis extracted their usul. Okay, so this is what is accepted in Islamic jurisprudence so far, and this is considered to be a consensus. These are the two methods, and the third method was adopted by some particular students of usul or scholars of usul who tried to combine between these two methods, the method of Mutakallimīn and the method of Fuqahā. So in order to combine them, and we have books which have been compiled according to these methods. We have the books compiled according to the method of Mutakallimun. We have books compiled according to the method of Fuqahā. We have books compiled according to the third method, which is Mazj, which is an amalgamation of both the methods. Okay, so the method of Mutakallimun is usul first, based on rational considerations. And of course, by rational considerations, we don't only mean pure aql, pure intellect, because we are talking about Sharia. So they extracted usul from Quran, from Sunnah, but pure usul. They did not see the corpus of masail and reflect on the considerations of their imams in giving a verdict or a masala and extract usul from that. No, they made usul first because their imam Muhammad ibn Idris al-Shafi'i also, he compiled a specific work on usul which is known as a-Risala. So usul first, and then they based furu on those usul. But in Fuqahā it is the opposite. Furu first, the masail, the verdicts, and then they extracted usul from it. This classification is widely accepted, but as I mentioned in the beginning, this is also confusing. Remember, the ilm of istilah is very important. Ilmul istilah. Ilmul mustalah or istilah. Mustalah is very important. The ilm of terminology. Mustalah is terminology. And it is the foundation of civilizations. Every civilization has its own terminology. And terminology is connected to mafahim, to concepts. As Islamic civilization, we have our own terminology. West has its own terminology. So decline happens because of al-khalt fil mafahim, confusion in concepts. Like take the example of the term development. development, when used in the Western perspective, means material, capitalistic, sophisticated, technological and scientific advancement. But when we use it in this term in Islamic perspective, it has a wider meaning, comprehensive meaning. So according to Islam, if we have a society which has reached the peak of technological and economic advancement, but it is corrupt in values, in morality and worldview, according to Islamic perspective, it is not a developed society, because Islamic considerations are something different. The concept of akhirah, hereafter, is important in Islamic worldview. It is foundational in Islamic worldview. So if we have a community which is underdeveloped technologically, economically, and in worldly parameters, in material, but it is the most upright community in morality, in religion, human beings are human beings, dehumanization has not happened. In Islam, we consider it, from Islamic perspective, the most developed community. So development has its own meaning in different perspectives and worldviews. And the decline in mustalahat, the decline in terminology, which are the carriers of concepts, is also from the primary reasons for the decline of our civilization. And this is a very important area which is neglected. Correcting our mafahim, correcting our concepts by fixing the mustalahat, fixing the terminology. For this reason, using the Arabic terminology directly without translating it is from the primary methods of fixing our concepts. So for example, the concept of haya, which is one of the primary values, it has great manifestations in human behavior. Haya, which we translate as modesty. We cannot translate it as shame, which will be a reductionist and wrong translation. The best word which we have for now is modesty. And it is again a closed concept, because it is between human beings. When we read the hadith in which the Messenger of Allah sallallahu alaihi wasallam said, "Inna Allah hayyiyyun kareem." Indeed, Allah subhanahu wa ta'ala is full of haya and kareem, generous. Will we say Allah is modest? What is the meaning of haya here? So using it directly in English, we say haya. It has different meanings when we use it for different people and different contexts. When we use haya with Allah, it means something different. When we use haya between human beings, it is something different. So ilmul mustalah is important. And we have khalt, we have confusion in some areas of knowledge in using the mustalahat. And this is one example. There are some contemporary scholars who understood this masala. Very few. I only know one scholar from Morocco, from the western part of the Muslim world, who understood this. And he worked on it. He compiled a book, an institute, to work on mustalahat, fixing the terminology, which are the carriers of concepts, Islamic concepts, as I said. So we can say he's from the propounders of ilmul mustalah in Islamic perspective, the science of terminology. His name is Sheikh Shahid Boushikhi. You may not have heard the name, because in our times, this is also from the signs of decline. We have the storytellers and the celebrity shuyukh and motivational speakers more famous. The real people who are working on the core and foundation of Islamic civilization are not so famous because of the decline we have. Muslim Ummah is not able to engage with them and understand the concepts they are promoting. So he compiled some works and he also established an institute. And I think it did not receive good from the Ummah, it was not accepted, or it is not so famous, but this is a very important revivalist methodology. So here also there is khalt, as we saw in the terminology of Ahlul Hadith and Ahlul Ra'i. We have khalt, we have confusion and problem in this terminology also. We will see how. But before that, as a side note, there are some scholars who may think that the method of fuqaha, it resembles the Western legal method based on precepts and statutes, the judicial engagement of the judges, because it's man-made system, as we explained. I will not go into that again. So usul, principles of law, are extracted from the masail. So it may resemble the Western method. They also extract the legal principles from the precepts, from statutes, from the judgment of the courts. They compile it, and these are the masail. These are not usul, these are masail. The different cases and the judicial engagements, statutes, precedents, these are masail. They reflect on it and they extract principles from it. Yeah, it may resemble, but this is not the case here. There are very important and intricate differences between the method of fuqaha if we accept this classification. As we said, there is no doubt that the term mutakallimūn, ilmul kalam, and the term fiqh, fuqaha, exists in our legacy. However, using these terms in this way, or classifying it in this manner, is problematic, in spite of the fact that this classification has been widely accepted in the contemporary Islamic jurisprudence, or between the contemporary scholars of usul al-fiqh. We should revise this classification, and this is the meaning of tajdeed also. Tajdeed, revival or reform. Revival is a better word. Is also going back to what we may take for granted. We may have accepted some concepts and some terminologies and classifications, but and in a wrong manner. Going back and revisiting, this is important. The first scholar to propound this classification is not a faqih or a legal expert, but rather a historian, Al-Imam Ibn Khaldun, rahimahullah. According to the research, the first scholar to propound this classification in a very explicit manner is Al-Imam Ibn Khaldun. In his famous work, Al-Muqaddimah, we engaged with Al-Muqaddimah in the history part, and we used it in other components of the Islamic worldview also. Al-Imam Ibn Khaldun, he writes in Al-Muqaddimah, because Ibn Khaldun also talks about ulum. He talks about religious knowledge and human knowledge and classification. He says, ثم أي بعد الشافعي كتب فقهاء الحنفية فيه كتب فقهاء الحنفية فيه وحققوا تلك القواعد وأوسعوا القول فيها. Then he says, after Shafi'i, he's talking about the compilation, the codification of usul al-fiqh. The Hanafi fuqaha, they compiled works in it, and they founded the qawaid, the principles, and expanded these principles. They applied these principles, they explained it. وَكَتَبَ الْمُتَكَلِّمُونَ أَيْضًا كَذَلِكَ. See, he is the first to propound this classification. And then he says, also mutakallimun, they compiled works in this field. So al-mutakallimun are the majority, or jumhur. The Shafi'is, the Malikis, and the Hanbalis. Primarily Shafi'is. And fuqaha are the Hanafis. Okay? إِلَّا أَنَّ كِتَابَةَ الْفُقَهَاءِ أَمَسُّ بِالْفِقْهِ. However, the work of fuqaha is more near to fiqh. وَأَلْيَقُ بِالْفُرُوءِ لِكَثْرَةِ الْأَمْثِلَةِ مِنْهَا وَالشَّوَاهِدِ. And it is more deserving with furu, yani it is more connected to the examples, the practical fiqh, because the works of Hanafis, the Fuqahā, here means Hanafis, they contain more examples. So it means the works of Mutakallimīn are mujarrad, usul, principles, without many examples. And the books of Hanafis, they are more connected with furu because they extracted the usul from furu, the opposite of the first method. So more examples and shawahid. وَبِنَاءُ الْمَسَائِلِ فِيهَا عَلَى النُّكَةِ الْفِقْهِيَّةِ, because they founded the masail on fiqh. They extracted usul from furu. والمتكلمون يجردون صور تلك المسائل عن الفقه ويميلون إلى الاستدلال العقلي ما أمكن. However, the mutakallimun, they adopted a different method. They created these usul based on pure rational considerations. Yes, Quran, Sunnah, they reflected, but they did not take the fiqhi corpus into consideration. Okay, لأنه غالب فنونهم, because this is dominant knowledge for them, or this is dominant on their fun. Yani they belong to ilmul kalam, and ilmul kalam is also as if, and we will come to the criticism also, understanding the correct meaning of this classification, as if Hanafis were never connected with ilmul kalam, or we don't have any mutakallim from Hanafis, and this is wrong. The greatest Hanafi scholar who founded one of the primary schools of ilmul kalam is Al-Imam Abu Mansur al-Maturidi, rahimahullah. So we have 4 schools, primary schools in ilmul kalam. We have the Ash'ari method in theology. It was founded by Al-Imam Abu al-Hasan al-Ash'ari, rahimahullah. Shafi'i, some even consider him belonging to other madhahib. We have the Hanafi, Imam Abu Mansur al-Maturidi, this is Maturidi method. And then we have the Hanbali method, which is pure based on athar, and it is also called athari method, without rational considerations, purely based on texts. The method of Al-Imam Ahmad ibn Hanbal. The 4th is Mu'tazili method, which is also very famous. And we know many Mu'tazila were Fuqahā also. Many Hanafis were Mu'tazila in creed, in Aqidah. Or we can say the majority of the Mu'tazila were Hanafis. For this reason, you will see influences of Mu'tazila in Hanafi ilmul hadith. And this is a different topic. Clear influences of Mu'tazila in accepting and rejecting the narrations, or the additional conditions which Hanafis have on the majority conditions of muhaddithun in accepting and rejecting the hadith. So Al-Imam Ibn Khaldun, rahimahullah, he says that the method of mutakallimun is purely rational. They have created the usul based on rational considerations, extracted from Quran and Sunnah, and that's it. And then they apply these usul on furu, because this is their fun. They belong to ilmul kalam, and theology is this method. لأنه غالب فنونهم ومقتضى طريقتهم. This is their method. فكان لفقهاء الحنفية فيها اليد الطولى من الغوص على النكت الفقهية. So Hanafis became masters in diving into the examples and practical masail, because this was their legacy, and they extracted usul from it. والتقاط هذه القوانين من مسائل الفقه ما أمكن, and extracting the qawaneen, the principles of usul, legal principles, methodology from these masail. This was the Hanafi method. And then he has even mentioned, so what is your evidence, O Imam Ibn Khaldun? We know Imam Ibn Khaldun was a great philosopher of history and sociologist, but this is not his field. Always remember, we may have great scholars, but take the knowledge of a particular field from its experts. We have Al-Imam Ibn Hajar, rahimahullah, who was a great muhaddith. In one of the places in his great commentary on Sahih al-Bukhari, Fathul Bari, in critique of a scholar who did not belong to ilm al-hadith, and he gave an opinion. He says, he says, whoever speaks in a fun, in a field of knowledge in which he is not an expert, ata bihadhil ajaib, he comes with these astonishing opinions. And this is true. If I'm not a physicist and I start speaking in physics, and I start critiquing the great physicists, I will become people will laugh at me, isn't it? Because I don't belong to this field. Man takallama fi ghayri fannihi ata bihadhihi al-ajaib. Whoever speaks in a field of knowledge in which he is not an expert, he comes with these ajaib. So we can apply this to Imam Ibn Khaldun also, with respect. So what is your dalil, O Imam Ibn Khaldun? He gives, his dalil is istiqra, yani he reflected on, where did you extract this? He reflected on the books of usul al-fiqh, and he extracted these two methods. But the problem is that this istiqra is istiqra'un naqis. This istiqra, which is a very important rational method in understanding the philosophical problems and reaching to conclusions, inductive method. And if we want to know the opinion of a locality, of a community, we go to every door one by one, asking their opinion about a particular problem. And then we conclude that this community believes in this opinion because I have been to door to door. This is called istiqra. But if you, for example, we have 100 people living in this community and you ask only 70 and then you conclude something, this will be istiqra'un naqis. This will be defective istiqra, because you have not taken the opinion of 30 people. How can you conclude that all people in this community believe in this opinion? So if you study only few books of usul in a wrong manner and conclude something, this will be a mistake. So for example, he says the method of fuqaha, the books written according to the method of fuqaha, he gives only one example of that, of the work compiled according to the method of Hanafis, which is Taqweemul Adillah of Al-Imam Abu Zayd al-Dabbusi, a great book of usul al-fiqh. And Mutakallimīn, he gives 4 primary sources, 4 primary books. Al-Burhan by Imam al-Haramain, Al-Imam al-Juwayni rahimahullah, Al-Mustasfa by Al-Imam al-Ghazali, and then we have the 2 other books by the Mu'tazila, Al-Ahad wal-Mu'tamad. So he says these are the 4 primary sources of usul al-fiqh. And this also became widely accepted in the books of usul, particularly the contemporary books. So as we said, and some contemporary scholars have also started doubting about this classification, but they are very few. You can point to them, count them on fingers. That's why I said this classification needs tahrir. So basically, this classification has problems. Why? Because usul can never be extracted from furu. And there are certain quotes from the Hanafi books. I have it here, but I will not go into that, maybe some other time, in which the Hanafis have clearly said that usul cannot be based on furu, or usul are the foundation for furu. So there is no doubt, yes, there is no doubt that the books of Hanafis contain more examples and more applications because of their greatness in fiqh, because of their great endeavor in the field of fiqh, and also due to the reason that they practiced fiqh. They became the great judges and qadis, and they were practically engaged into polity and community. So when you're practically engaged, you will have verdicts, and yani, it will nurture your legal understanding. So the Hanafis, they became qadis, and even the title of Qadi al-Quda, the Chief Justice, was created for the Hanafi Imam, Al-Imam Abu Yusuf, rahimahullah. So who would supervise the qadis? He became the Chief Justice, as we use it in modern legal jargon. So there is no doubt the method of Fuqahā became is the method of the Hanafis. Let's say method of the Hanafis is more rich in examples, in practicality, and the books compiled by other madhahib, compiled by the Shafi'is and Malikis and Hanbalis, may contain less examples or some repeated examples. There is no doubt in that, but this does not mean that Hanafis did not have any usul. The problem is, one of the main problems is that the early books which have not reached us from the Hanafi scholars, and the Hanafi sources claim that the early scholars, including Al-Imam Abu Hanifa himself, compiled books about usul, Kitab al-Ra'i, Kitab al-Usul, and other books. And of course, the books of the immediate students have reached us. The books of Al-Imam Muhammad ibn al-Hasan al-Shaybani, we have the book of Al-Imam Abu Yusuf, and other works. And we have to understand the shift in methodology of compilation, also writing. The writing method by the early Tadween, the method of compilation writing, was different when we compare the early age and when the terminology was settled, the classifications were accepted in the works. So the early method of the scholars immediately after the Sahaba was a different method. Like we see in the books of hadith also. The early books of hadith are not only books of hadith in pure sense. The early books of hadith, they contain sayings, actions, and approvals of the Prophet, the fatwa of the Sahaba, the practice of the Sahaba, Tabi'een, sometimes the opinions of the Imam, the Muhaddith who is compiling that book. If you see the early works like Muwatta of Imam Malik, Musannaf of Imam Ibn Abi Shayba, Musannaf of Abdul Razzaq, and all these early books, you will find that everything is mixed in that. And it is a book of hadith. But later on, this separation and classification in order to create ease for understanding happened. So in the age of 6 books of Sunnah, Bukhari, Muslim, Tirmidhi, Abu Dawud, Ibn Majah, Nasai, and other books, this shift happened. So based on this, can we say that the early scholars, they did not consider hadith, or they did not consider legally binding only Sunnah of the Prophet, but rather the actions of the practice of the Sahaba was also legally binding. The fatwa of Tabi'een was also legally binding. His own opinions, which he mentions after these fatwa and practice, is also legally binding. We cannot say that. We cannot say that. Only because everything was mentioned together and compiled together in these books. What we can say is that this was a different method. This was an early method. And in every field of knowledge, development happens. The beginning of every field is more broader and comprehensive, and slowly these classifications happen and separations in order to clear the field of that particular field of knowledge, and also to create ease of understanding for those who engage with that field. Same happened here. So the early books, before the advent of Ilmul Kalam, because Ilmul Kalam was founded and created for a particular purpose. It's Ilmu Darura, as the scholars say. It is the ilm of necessity. When the Romans and the Persians and different people accepted Islam, they came with their cultural baggages and backgrounds. They had questions, doubts. They were not Arabs, simple people in philosophy. The guitar of the Arabs had only one string. It was not like that. Persians, Romans had legacy. They had their own concepts. So it was, they had their questions. They came with their cultural baggages. For this reason, ilm al-kalam was created to confront the contending ideologies and to answer to engage in argumentation, so on and so forth. That's why it's also ilm al-kalam is ilmun jadali. It is a field of knowledge which is founded on argumentation. It is not ilmun ta'sisi. It is not an original and foundational field of knowledge. It was created for a purpose. So before ilm al-kalam, before mutakallimīn, we have contributions from all these madhahib. We have the early Shafi'is, we have the early Malikis, the Imams themselves, we have the early Hanbalis, we have the early Hanafis. We don't see classification methods in their books. So what will we reject those books? So in order to reach a conclusion, these early books should have been taken into consideration. We cannot base our understanding on only 4 books, 5 books, 6 books, 10 books, particularly compiled by mutaakhirin. So this is the problem. Okay, but this needs further research. We have not reached any conclusion. I just wanted to discuss this mas'ala for a particular reason, and that is the presence of plurality and diversity in our legal method. So we can say one of the main pinnacles or the primary feature of Islamic legal methodology or Islamic legal tradition is its diversity and protecting that diversity, which is missing in the Western legal tradition, because Western legal tradition was based on the concept of state, nationalism, nation state, and the state control of the legal structure, as we have mentioned before. So we have said that, and this is against diversity. State controlling the legal structures, institutions, and the methods is basically one of the main primary features of the Western legal tradition. So we in Islamic legal tradition, we stood for plurality and diversity, and this was maintained. The states in our history which adopted a particular madhab does not make it normative, because they were not Sahaba. The Abbasids, if they adopted Hanafi madhab, and the scholars agreed to that for any particular reason, and this is their valid ijtihad, we respect it, does not make it normative, does not mean that this is something which was accepted by the Sahaba and this is one of the principles of our tradition. No. We gave the example of the famous Khalifa Abu Ja'far al-Mansur, when he requested al-Imam Malik to make Muwatta the legal code of the Khilafah. He rejected, and he deserved, his book deserved, his legal understanding deserved to be the legal code. Why did he reject? And we have different narrations in that. He said, Innal ashaba qad ikhtalafu. The Sahaba have spread in the Muslim world. We have scholars, they have disagreed. I don't want to disturb this diversity. Subhanallah. This is very important. He did not. Let's keep this diversity. We have the foundations of Islamic law as Khalifa, as the political authority. Your duty is to understand this law and apply it. So your duty is to prove your loyalty to the interpretive community, the scholars. And I don't want to go back to the discussion. We explained this main difference between the Western system and the Islamic system. In the Western system, it is the political authority which decides the law, applies the law. But in the Islamic system, the political authority, in order to validate itself, has to prove its worth by applying this Sharia in their personal lives, the rulers, and also implementing the Sharia in the society under the guidance of these scholars. And we see that the Khalifa Abu Ja'far al-Mansur was inclined to the Ahlul Hadith method, because we have this narration in the original sources that he wrote a letter to Al-Imam Abu Hanifa. He said in that, بلغني أنك تقدم القياس على الحديث. It has reached me that you prefer qiyas on hadith, you prefer analogy on hadith. So this is a problem. فقال Al-Imam Abu Hanifa, he replied, ليس الأمر كما بلغك يا أمير المؤمنين. This is not true, O Amir al-Mu'minin. إنما أعمل أولا بكتاب الله. Imam Abu Hanifa explained his method. He says, I apply primarily the book of Allah, ثم بسنة رسول الله صلى الله عليه وسلم, then the sunnah of the messenger صلى الله عليه وسلم, ثم بأقضية أبي بكر وعمر وعثمان وعلي, and then I take guidance, legal guidance, I apply the verdicts of Abu Bakr, Umar, Uthman and Ali رضي الله عنهم, ثم بأقضية بقية الصحابة, and then the verdicts of rest of the Sahaba, particularly the Mujtahid Sahaba. ثم أقيس بعد ذلك إذا اختلفوا. And after that, if I don't find guidance in the book of Allah, the sunnah of the messenger, the verdicts and practice of, if they have ikhtilaf, the Sahaba have difference of opinion in a matter, I apply qiyas in that. I apply analogy. So this is not true that I prefer qiyas on hadith without any conditions. So this narration also makes us understand that Al-Imam Abu Ja'far al-Mansur was inclined to the Ahlul Hadith method. And the Imam of Ahlul Hadith was Imam Malik. Before Imam al-Shafi, we explained about the shift which happened. For this reason, he requested Imam Malik to make Muwatta, to take Muwatta as code of the state. And this is exactly the reason for the decline of Islamic law in the Muslim world when the modernization project was initiated by the colonialist regimes. Inshallah, we'll talk about this in the next session. Modernization of Islamic law, how Islamic law declined in the Muslim world, the Sharia, and the methods adopted by these colonial powers in destroying the structure of the Sharia, which was deeply embedded in the Muslim societies. One of the primary methods which they adopted was codifying it. And codifying is again bringing the law within the state structure. You have a diverse law with different madhahib, different positions, fuqahā, 4 schools, diverse verdicts. You codify it. So al-ahkam al-adaliyah, the codification, early codification in the Uthmani period which happened, is not the pinnacle of what we have produced. Some people think that al-ahkam al-adaliyah, it is the book in which Islamic law, the Hanafi madhab, which was the law of the Uthmaniyun, was codified in the form of the modern, the Western modern codification method, article wise. This is not, this is destroying the diversity and fluidity of Islamic law. Okay, so they understood that this diversity and pluralism, if we can use this term in a very restricted legal manner, is the strength of Muslim society and Sharia. If we want to destroy it, the initial method would be to codify it, to restrict it, to reduce it to certain codes, which will serve our purpose. Okay, so we have said one of the most salient features of the nation state is its totalistic appropriation of the domain of law. One of the main salient features is totalistic appropriation of the domain of law, yani domination, destroying this diversity, and appropriation that presupposed centralization and bureaucratization of the legal system. So don't leave this law open in the society and the Sharia. People are connected with the ulama and this interpretive community, different madhahib. The political authority, in order to prove its worth and to validate itself, has to go through this system, destroy it. Let's take everything in our hands. This is the peculiar work of the modern nation state, or one of the main characteristics. So totalistic appropriation of the domain of law, and appropriation that presupposed centralization and bureaucratization of the legal system. So these are some masail which I wanted to discuss in today's session. Inshallah, in the next discussion, we will talk about modernization of Islamic tradition under European, particularly French influence, the colonial influence in the early 18th and 19th centuries. The first westernized commercial code was promulgated in 1850. So how did the Western colonial powers, how did they initiate the destruction of the Islamic legal system in the Muslim world? Inshallah, we'll talk about that. And the marginalization of the Sharia was thus itself an act not only of dismantling, so it was not only destroying the Sharia, dismantling it, but also of building a system of courts and law that functioned to serve the state. And this was the main shift which happened. This was the destruction. The Sharia in the traditional Islamic legal system was never meant to serve the state, but the state would serve the Sharia. State would, to prove its validity, would serve the Sharia and the Islamic legal system, which was founded and maintained and preserved by the scholarly class. So this is what happened. Inshallah, we'll talk about this more, the modernization which happened in the early 18th and 19th centuries. In the next session, we ask Allah subhanahu wa ta'ala to grant us understanding. We ask Allah subhanahu wa ta'ala to revive the Sharia in the Muslim world and give us tawfiq of applying the Sharia in our lives, in our societies. We ask Allah subhanahu wa ta'ala nusrah for all those who are supporting and aiding the cause of Muhammad sallallahu alaihi wasallam. We ask Allah subhanahu wa ta'ala to grant us tawfiq of speaking the truth, applying the truth in our lives, standing for the truth. May Allah subhanahu wa ta'ala destroy those who aim to destroy the cause of Muhammad sallallahu alaihi wasallam. We ask Allah subhanahu wa ta'ala by his beautiful names and exalted attributes to grant nusrah to our brothers in Palestine, in Gaza, in Kashmir, in all places in the Ummah. We ask Allah subhanahu wa ta'ala to give us tawfiq of standing for the rights of the weak Muslims, oppressed Muslims around the globe. We ask Allah subhanahu wa ta'ala by his beautiful names and exalted attributes to accept their martyrs, cure our sick, and forgive all our dead. Ameen ya Rabbal Alameen. Wa sallallahu ta'ala ala nabi al-ummi. Wassalamu alaikum wa rahmatullahi wa barakatuh.